Ready. Start. On a writ petition being preferred by the appellant in assailing the interference made by the tribunal in exercise of its power under section 11A of the Act 1947, the learned single judge by an order dated 25th July 2006 dismissed the petition, holding that the tribunal has a discretion under section 11A of the Act 1947 and held that it has rightly been exercised, which further came to be challenged at the instance of the appellant in letters patent appeal before the division bench of the High Court. Stop. The division bench has upheld the finding returned by the tribunal and confirmed by the learned single judge under the order impugned, which has been categorically referred to in para 3 of the order. Stop. However, the division bench was not inclined to interfere despite the fact that the respondent was found guilty after regular inquiry being held for misappropriation of funds, and further observed that there should not be any compassion in the judicial proceedings, which should be shown to be delinquent who commits such nature of fraud in discharge of his duties, but still refused to interfere with the order of the tribunal for the reason that the respondent employee by that time had retired on attaining the age of superannuation in 2007. Stop. The relevant para is that it appears to us that the tribunal agreed with the finding of fact recorded by the learned inquiry officer that had found him guilty of misappropriation of funds. Stop. However, the learned tribunal also observed that it was perhaps a case of bona fide error leading to alteration in the punishment. Stop. We felt that the learned tribunal was not justified in disagreeing with the finding of fact recorded by the learned inquiry officer. Stop. It does not appear to us to be a case of bona fide error, but was really a case of well thought out plan to divert funds from other accounts to a fictitious account opened by him. Stop. In such a situation, reduction in punishment also becomes a case of uncalled for interference. Stop. The learned tribunal also seems to have given weightage to the domestic situation in the employee's family, which we once again feel to be a wholly unsatisfied ground to dilute the guilt of the employee. Stop. Law is well settled that needless compassion should not be injected into judicial proceedings. Stop. We do not agree with the order of the learned tribunal nor that of the learned writ court. Stop. However, we would have interfered with the order of the learned tribunal, but we refrain from doing so because the employee has already reached the age of superannuation way back in the year 2007. Stop. We have heard learned counsel for the parties. Stop.